I had the pen in my hand. I had already written the number down. I just had not said it out loud yet. And in that silence, the woman at the defense table looked at the wall. Not the floor. The wall. Like she was waiting for a bus. And I thought, she still does not understand what she did. That was the moment. That is the one I keep coming back to. Let me tell you how we got there. Before I go further, I need you to subscribe. Not as a formality, because there is one piece of evidence in this case, something small, something easy to overlook, that changed the direction of my ruling entirely. I want to make sure you are here when I get to it. Subscribe now, then let me continue. I have been sitting on a bench for 22 years. I have presided over more cases than I have kept count of. I have heard things in that courtroom that I still carry home with me at night. But this case is the one that made me want to talk out loud, not to my colleagues, not to my family, though I tried once. I want to talk to the people who were not in the room, because what happened in that courtroom needs more ears than it has found. So I am going to tell it, the way I experienced it, from that bench. The victim's name was Gerald Morrow. He was 63 years old. When Gerald walked into my courtroom for the first time, I watched him the way I always watch people before they know I am really looking. He moved slowly, not the way someone moves when they are tired, but the way someone moves when every step is a decision. He had a thin gray coat on even though it was August. He sat at the plaintiff's table and put both hands flat on the surface in front of him, like he was steadying himself. He did not look at the defense table. He looked straight ahead. He had a yellow legal pad with him, dark ink. He referred to it throughout the proceedings using a small magnifying glass he kept in his coat pocket. He never asked anyone to slow down for him. He just quietly pulled out that glass and read what he needed to read. That detail told me more about Gerald Morrow than any character witness ever could. The defendant's name was Renata Solano. She was 48 years old. 11 years as a nurse supervisor in the emergency department at Crestfield Medical Center. When she walked in that first morning, she moved quickly, purposefully. Dark blazer, leather portfolio tucked under one arm. She sat, opened the portfolio, and started reading. She did not look at Gerald, not when he walked in, not when he sat down 5 feet to her left. I have learned over 22 years to pay attention to where people do not look. It tells me more than where they do. When her attorney whispered to her before the session opened, she nodded with a kind of impatience, not the impatience of someone nervous, but of someone who believed they should not have to be there. I wrote one word in my notes that morning. I did not cross it out. Now let me tell you what happened, the way I know it from the file and from every hour of testimony. It was the night of March 7th, a Tuesday. At 9:42 p.m., Gerald Morrow arrived at the emergency department of Crestfield Medical Center in Harlan County. His daughter Patricia, 31, brought him. Gerald had been diagnosed 18 months earlier with stage 4 pancreatic cancer. His oncologist, Dr. Felicia Okafor, had a standing pain management protocol on file, a signed documented order authorizing ER staff to administer specific medication when Gerald presented in acute distress. This was not a gray area. This was paperwork, filed paperwork. Patricia told the intake nurse her father was in severe pain and had been unable to keep oral medication down for 6 hours. Gerald was triaged and assigned a room. The on-call physician, Dr. Amit Patel, reviewed the file, confirmed the standing order, and verbally authorized the medication at 10:08 p.m. according to the time-stamped nursing log entered into evidence. The medication was not given. At 10:31 p.m., Renata Solano was paged about Gerald's case. She reviewed the file. Then she told the nurse assigned to Gerald, 26-year-old Cara Hendricks, that she was holding the medication pending a second physician review, citing concern about the dosage relative to Gerald's recent intake records. Cara Hendricks testified that she said, "But the standing order is already on file." And Renata Solano said, "I am the supervisor on this floor and I am telling you to hold it." That is a direct quote from sworn testimony. I wrote it down. I have not forgotten it. Dr. Patel was occupied with a trauma situation and unreachable for 47 minutes. The second physician Renata contacted, Dr. Marcus Webb, did not review the file until 11:34 p.m. He confirmed the standing order was appropriate. Gerald finally received pain management at 11:51 p.m., 1 hour and 43 minutes after it was first authorized. During that time, Patricia Morrow made 3 requests at the nursing station. She was told each time a review was in process. Gerald testified about that night. He said, "I have been in pain before. I know what pain is. That night was different. That night I kept thinking someone had made a mistake about who I was. I had to sit with that sentence for a long time. If you are still with me, and I think you know why you are, then subscribe to this channel. This is what I do now. I tell the stories that need to be told, not the easy ones, the ones that stayed with me after the gavel came down. Subscribe, then let me continue." This case came to me as a civil proceeding. Gerald and Patricia Morrow filed suit against Renata Solano individually and against Crestfield Medical Center as her employer. The claims included medical negligence, intentional infliction of emotional distress, and a civil rights claim under a state health care statute that most people, even most attorneys, do not immediately think of in a case like this. That statute protects terminally ill patients from the arbitrary withholding of prescribed comfort care. It was passed in 2009 after a series of incidents in long-term care facilities that never made the news the way they should have. The hospital settled before trial. What remained before me was the individual claim against Renata Solano. I arrived early the morning trial opened. The courtroom was still empty. I sat at the bench and looked at Gerald's medical file, which I had already read 3 times, and I reviewed the exhibit list. Exhibit 14 was labeled Nursing Log, March 7th, handwritten notation, 10:09 p.m. Something about that timestamp felt important. I was right about that. When the parties entered, Gerald came in with Patricia and a younger man, his son Thomas. Same gray coat. He sat and put his hands flat on the table. Thomas sat behind him and placed one hand briefly on his father's shoulder. Gerald gave a small nod without turning around. That was the only visible exchange between them for the entire first session. Renata Solano walked in behind her legal team, sat, opened the portfolio, did not look at Gerald. The evidence came in 3 waves, and I want to tell you how each one landed from where I sat. The first wave was the baseline, the medical record, Dr. Okafor's standing order, the timestamps showing the gap between authorization and administration. When Exhibit 14 came in, that handwritten nursing log notation, I read it carefully. In Renata Solano's own handwriting, in the margin next to Dr. Patel's verbal authorization, she had written 2 words, flag, review, 2 words, in the margin, next to a standing order already approved by the patient's oncologist. I held that exhibit a moment before passing it along. The defense argued in the first wave that Renata was exercising appropriate clinical caution. Her attorney presented 3 patient files from the prior 2 years where she had flagged medication orders in similar fashion. That argument had weight. I gave it weight. Supervisory caution is not wrong on its face. The second wave was where things became more complicated. Patricia Morrow testified. She described the 47 minutes she spent watching her father try to stay still in that hospital bed, 3 trips to the nursing station, then returning to Gerald's room and him looking at her and saying, "Just take me home." She told him they could not leave yet. He said, "Then sit with me." She sat. She held his hand. She did not tell him how long it had been. I am going to stop here, because what I am about to tell you is the part of this case I had to sit with the longest before I felt ready to speak about it publicly. Subscribe before we go further. Take a breath. Because this next part matters. Dr. Okafor testified by video deposition in the second wave. She said directly and without elaboration, "The standing order exists precisely so that this does not happen." And then came the piece of evidence I had flagged for myself before the trial began. A text message sent from Renata Solano's personal cell phone at 10:17 p.m., 9 minutes after the verbal authorization, 26 minutes before the second physician reviewed the file, to a colleague not on duty that night. The text read, "Got a 63M with a DNR and a standing narcotics order. Family is pushing hard. I don't like the feel of this one." That was the second wave. The third wave changed my ruling in a specific way. Gerald's case manager, Dolores Wright, testified that 2 weeks before March 7th, she had received a formal written complaint from Patricia Morrow about a previous ER visit where Gerald experienced a delay in pain management. That complaint was routed through the hospital's patient services office. Dolores testified she had personally flagged it to the nursing supervisor for Gerald's department. That supervisor was Renata Solano. In her own deposition, Renata Solano said she did not recall receiving that complaint. When Dolores Wright stepped down, I looked at the defense table. Renata was writing something in her portfolio. Her attorney put a hand on her arm. She stopped. Now let me tell you one thing about myself. Just one moment. My mother was 61 when she had a fall and was taken to an emergency room alone. None of her children nearby. It was a Friday night. She waited 4 hours in a hallway before anyone examined her. When I spoke to her the next morning, she told me she had been afraid to ask for anything because she did not want to be seen as difficult. She had a fractured wrist, 4 hours in a hallway, afraid to seem difficult. I never told her that stayed with me, but it did. When Gerald said he kept thinking someone had made a mistake about who he was, I had heard that feeling before, in a different voice, on a different phone call. Now, the defense. Renata Solano's attorney argued 3 things fairly, and I am going to give them to you fairly. First, her documented record of clinical caution was real and had been recognized by hospital administration in prior years. Second, gaps in Gerald's intake records on March 7th were genuine and warranted a second look. Third, the delay, while regrettable, was not intentional and did not meet the threshold for civil liability. The first argument had substance. The second had surface logic but collapsed against Dr. Okafor's deposition. Gaps in intake records do not affect a standing order. Those are 2 different documents addressing 2 different things. The third argument was the one I found least persuasive, particularly in light of the text message and the prior complaint. Renata Solano testified in her own defense on day 3. She was composed and articulate. She spoke about her 11 years of service, the complexity of managing an ER floor, the weight of supervisory responsibility, and then asked by her own attorney why she held the medication that night, and she said, "He had a DNR on file. I needed to understand the full picture before I acted. He said it. I wrote it down." A do not resuscitate order is a patient's documented wish regarding resuscitation at the end of life. It carries 0 clinical bearing on whether a patient in pain should receive prescribed comfort care. 0. Those are entirely separate documents addressing entirely separate decisions. And she said, "I needed to understand the full picture." I have been doing this for 22 years. The cases I choose to talk about publicly are ones I believe need to be known. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. Now I want to tell you what the room felt like when I was ready to deliver the verdict. I had made my decision days earlier, if I'm honest, but the moment still lands differently when it is spoken out loud. Gerald was at the plaintiff's table in a blue button-down shirt. No gray coat that day. He looked like a man who had spent a very long time getting to this room. Patricia sat beside him. Thomas was behind him. Renata Solano was looking at her portfolio. The room went quiet in the specific way courtrooms do just before a verdict. Not silent exactly, but as if everyone has stopped pretending to breathe normally. I looked at my ruling. I looked up, and I began. I found in favor of Gerald Morrow and against Renata Solano on all counts. Patricia put her hand over her mouth. Just that. No sound. Thomas leaned forward. Gerald looked down at his yellow legal pad and did not look up for several seconds. The verdict was not the hardest part of this case. The sentencing was. Because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I am ordering you, Renata Solano, to pay $240,000 in compensatory damages to Gerald Morrow. This figure reflects the documented harm of 103 minutes of unmanaged pain in a man with a terminal diagnosis, the cost of additional medical care required afterward. It is not symbolic. Every dollar is calculated. I am also ordering that your nursing license be suspended for 18 months with a mandatory supervisory restriction for 24 months upon reinstatement. You may not hold a charge or supervisory nursing position during that period. You may work as a staff nurse. What you may not do is hold authority over other nurses' clinical decisions regarding pain management for patients in end-of-life care. That specific authority I am removing from you. I am ordering 200 hours of community service at a licensed hospice facility under the supervision of a palliative care coordinator, not in an administrative role. Direct patient contact within 6 months of today. I am ordering you to write a formal letter of apology to Gerald Morrow, to Patricia Morrow, and to Thomas Morrow. That letter must be a minimum of 500 words. It must be read aloud by you, in your own voice, at a patient advocacy training session hosted by the County Medical Board, with no fewer than 30 licensed healthcare professionals present. A recording will be filed with this court, and I am ordering you to fund Gerald Morrow's in-home palliative care coordination for 12 months. The coordinator will be selected by Dr. Felicia Okafor. Payment will be made directly and in advance, on a quarterly basis. This is not reducible. Now I want to tell you what I said directly to Renata Solano in that courtroom. I want to say it again the same way. What you did on the night of March 7th was not a mistake. Mistakes happen in moments of insufficient information. You had the information. You had a standing order from his oncologist. You had a verbal authorization from the physician on duty. What you chose to do with that information cost a 63-year-old man with terminal cancer 103 minutes of unmanaged pain. In the time he has left, time is not abstract, it is measured, and you took 103 minutes of it and filled it with something it did not need to contain, to your family. Nothing I am ordering today reflects who you are. It reflects one decision, made by one person, on one night. To anyone who holds clinical authority over another person's comfort, that authority is not a ceiling, it is a weight. It carries something that belongs to someone else. Every time you exercise it, you are carrying that. It is not a responsibility to be managed. It is a responsibility to be honored. And the last thing I said to Renata Solano in that room, Gerald Morrow did not need to prove he deserved pain relief. He just needed someone to give it to him. Thank you for staying with this. I mean that. Subscribe if you have not yet. You already know why you are still here. When the room began to empty, I stayed at the bench. I watched Thomas help Gerald stand. Gerald paused with both hands on the edge of the table, the same way he had on day one. Then he straightened. He walked toward the door and he stopped once, just once, and looked back at the room, not at the defense table, not at me, just at the room, like he was confirming something for himself. The room felt different after he left. I stayed a few more minutes. When the bailiff began turning chairs, I stood, walked back to my chambers, sat at my desk, and did not immediately open the next file. The appeal was filed 41 days after my ruling. The 3rd District Court of Appeals heard it. 7 months later, they upheld my ruling in full. The written opinion said the trial court's findings were supported by substantial evidence and that the damages awarded were proportionate to the documented harm. 7 months. I was not surprised, but I was relieved. Gerald Morrow died on September 14th of that same year. He was at home. Patricia wrote a brief letter to the court afterward. She said he spent his final 3 months with the palliative care coordinator Dr. Okafor selected. She described those months with one word: peaceful. She did not elaborate. She did not need to. Renata Solano completed her community service at Harlan County Hospice. At the 6-month mark, the coordinator there, Marilyn Cross, filed a report with the court. She noted that Renata had been present, attentive, and had, this is a direct quote, on one occasion stayed an extra 2 hours without being asked to sit with a patient who had no family present. I do not know what to do with that. I am not going to tell you what to do with it either. I am just telling you it happened. On a Wednesday in November, that is what I know. What this case left me with is not a conclusion. It is a question I still sit with, and the question is this: when does professional authority become the very thing it was designed to prevent? Renata Solano was trained to protect patients. She had spent 11 years doing that, in her own accounting. And on one night she used the tools of protection, caution, review, oversight, to produce something that looked, from inside that courtroom, like the opposite of protection. I have thought about that gap many times, the gap between what a thing is built to do and what it actually does when held by a particular person in a particular moment. I have seen that gap in other cases, in finance, in family court, in institutions designed specifically around care. The gap is not unique to medicine, but in medicine, the distance between protection and harm is measured in minutes. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. To anyone who has ever been in Gerald's position, not necessarily a cancer diagnosis, but the specific position of needing something from someone who had the authority to give it and being made to wait without explanation, without anyone looking at you and saying your name, I want you to know this. What you felt in that room was real. It was not a system failure in the abstract. It was a human being making a choice. And that distinction matters because it means it is not inevitable. It means it can be different. Gerald Morrow maintained something in that courtroom, a kind of quiet, undemonstrative dignity that the process had not been able to take from him. I saw it. I want you to know that I saw it. To anyone who has held the kind of authority Renata Solano held that night, clinical, institutional, the authority to approve or delay, I want to ask you one question. When was the last time you genuinely considered what it costs the other person to wait? Not the system, not the review process, the person in the bed. If you can answer that honestly, you already know what to do next. If you cannot, if the question sounds like an inconvenience, I am asking you to sit with it until it does not. I keep coming back to that yellow legal pad. Dark ink, Gerald's magnifying glass beside it, his hands flat on the table. A man who came to a courtroom to fight for something that should never have required a courtroom, who brought his magnifying glass so he could read his own notes, who prepared, who showed up, prepared, and sat in that room with his hands steady and his eyes straight ahead. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if something here stayed with you the way it stayed with me, leave it in the comments. That is where people who care about the same things find each other. Gerald Morrow.